Practical considerations in dealing with incapacity. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Tony Ann Cruz, ACTEC Fellow from New York. Today, we will build on previous podcasts regarding clients with incapacity and specifically practical considerations in estate planning and litigation when dealing with incapacity. ACTEC Fellows Brad Gallant of New Haven, Connecticut, and Julia B. Meister of Cincinnati, Ohio, will share their thoughts. Welcome, Brad and Julia.
This is Brad Gallant. Hello. One of the things that Julia and I really want to make clear to everybody is that this whole talk and our presentation at the ACTEC National Meeting earlier this year is all about how to avoid adult guardianships. And there are a lot of reasons why you want to avoid them. There are ethical reasons, there are practical reasons, there are, also just client relationship reasons. But I think we all agree that 9 times out of 10, an adult guardianship is a disaster for the entire family and the lawyers. From my perspective as a planner, it's particularly undesirable because it's very difficult to write documents where someone is actually adjudicated incapacitated, incapable, whatever the language is in your jurisdiction. But the process is a bad one too. And Julia is going to speak about that for a second.
Sure, Brad. Thank you. So yes, we do have this emphasis on avoiding guardianship. Let's talk a little about that. Why is it that we want to avoid guardianship? Well, anybody who's seen the movie I Care a Lot, which is fiction, but has just enough of a kernel of truth in it to make it of interest and scary to all of us, they know that guardianship means losing control. That's the main reason that we want to avoid guardianship, because your affairs aren't being managed according to how you did your documents, how you did your plan. They're being managed completely by a guardian who, although they have guardrails around their conduct, they also have a lot of discretion and control over the life of their wards. Just ask Britney Spears about that. And also ask those on the Senate committee that has proposed guardianship bills of rights and reform laws. This is a very serious subject that people are deeply concerned about, and rightly. So when capacity is diminished or lost, we do want to avoid guardianship if we can, because it's distressing, cumbersome, invasive, and frankly, inefficient. And the concept of capacity also comes up in litigation, where we may be talking about the validity of documents, the validity of certain transactions based on whether a person had capacity at the time or not. Primarily, though, today what we're focused on is thinking about avoiding guardianship, anticipating and dealing with diminished capacity issues, loss of capacity issues, which are going to happen. And what can we do about that in the drafting? So I'm going to throw this back to Brad and say, Brad, can advanced planning, doing perfect, expert, meticulously drafted documents entirely avoid the possibility of guardianship, avoid these problems that we confront when we have a person with diminished capacity?
Well, Julia, the short answer is no. The better answer is it depends. But in fact, 9 times out of 10, avoiding guardianship has more to do with the facts and circumstances that arise at the time the capacity is becoming diminished, with the family dynamics, with the personality of the client. Those are the types of issues that are more likely to determine whether or not you have a contested adult guardianship. People talk about using powers of attorney as an alternative to a guardianship. Sure, that works as long as nobody challenges the power of attorney holder, as long as nobody tries to demand an accounting, tries to allege that there was either incapacity at the time the power was signed or that other acts were done without capacity. Another way of approaching the issue is by the use of revocable trusts. But again, depending on who the trustee is, depending on whether or not there are allegations that a trustee, which we'll talk about later, is incapacitated, whether or not the document was signed at a time of incapacity. And of course, there's also the issue where the settlor of the Rev Trust, your client, decides that she isn't incapacitated and she wants to take the assets out of the Rev Trust. So this is really a difficult situation. And when that arises, we usually end up in probate court, as you know, Julia. And that means that, someone like you gets involved. And how does that look from your perspective once we have these beautiful documents, but the family's still at war?
Well, Brad, it certainly is not where you want to be. And I think I hear you saying that even the best drafted documents cannot account for the human circumstances and practicalities that arise. We just try our best with these documents. But sometimes, as you say, we wind up in disputes, we wind up in court. And so how does that start? Well, it usually involves some sort of an expert opining on whether a person has diminished capacity or is incompetent or whatever the standard in the particular case and jurisdiction is. You're confronted immediately with the issue of how could a person who knows enough, is aware enough, has enough capacity to understand what's going on if that person doesn't want to be evaluated? There's a process to deal with that. It's terrible to see it happen because people don't like it, but there's a process where a court can order an evaluation by a qualified professional. What do I mean by a qualified professional? Well, this depends on variations in state law, but generally speaking, we're talking about medical doctors, MDs, DOs. We may be talking about psychologists or psychiatrists. We may be talking about neuropsychiatrists, neuropsychologists, and other particular types of evaluators. And a court can put on an order mandating that an evaluation be performed. And that's usually what gets things started. But that's just the beginning.
Sometimes, Julia, when I'm worried about capacity and I'm worried about a challenge to the documents, I'll say to my clients, listen, I wouldn't do this with you if I didn't feel that you've got the capacity, and I wouldn't, and if I didn't feel you had the capacity to execute these documents. But who cares what I think? And so why don't we instead get a professional involved who can evaluate you in a place you feel comfortable, at home, maybe in their office, but probably at home. And that way, when that awful niece of yours tries to challenge your will, we'll have something to roll out right in front of them and say, ha, we've got you. And in fact, Julia, I've seen this work sometimes. And as a litigator, if the drafting attorney appears with documents signed by a qualified psychiatrist or other professional, doesn't that really pretty much make the case that the individual had capacity at that time? Is there very much left to challenge from your perspective?
Certainly, it's argued to be the case that things can be challenged. I mean, challenges are always going to be attempted and made if someone wants to do that. There's a discovery process where the circumstances of the execution of documents is delved into deeply, where the qualifications of the evaluator, where biases of the evaluator are explored, where the presence of interested people and the potential influence of those people on the process are explored, all those things. So you are pointing out something that certainly is recommended. I highly recommend to anyone listening the ABA's recently published guide on dealing with clients with diminished capacity. It contains a very nice primer on how to go about assessing capacity in circumstances like these you've been describing, Brad, where perhaps you're anticipating challenges and you want to head those off, or there's some other special circumstance that you have to be attuned to.
One thing that I found to be quite helpful in dealing with this situation is get your ducks in a row and get your, professional opinion that you have capacity, and then create a revocable trust where you have a corporate fiduciary involved. Maybe even take away the role of the individual, if the client is willing to do that, with a power in the individual to remove and replace the corporate fiduciary. That tends to make life easier as long as the client is cooperative. And it also makes it very difficult to challenge not necessarily the creation of the document, but the subsequent acts. Because as far as I know, no one's ever accused a trust company of lacking capacity. I mean, they may not like certain types of investments, but from our perspective, they have capacity. But there is that other problem, Julia. What if that trustee is not a corporate fiduciary, but a friend, a relative, and that individual starts to have capacity issues? Where do you go then?
The first thing you do in either case is look to the document, see what the document says about removal and replacement of trustees. You look at the statutory and common law of your jurisdiction about the removal and replacement of trustees. And then you're back to the question that I raised in connection even with guardianship. If you're alleging that a person shouldn't be serving as trustee anymore because they lack capacity to serve in that office, whether that person is the grantor who originally was serving as their own trustee, then to be followed by a successor, or whether you're talking about someone who is a successor different from the grantor. How do you get that person to submit to the evaluation that I've been talking about? There are ways within litigation to make that happen, but that is not really where we want to be. You've hit on something that I wanted to discuss here, and that's the notion of transition from the original trustee to successor, or from successor to a subsequent successor. And that's what I call triggering provisions, if you will, levers that exist in the documents so that when a person develops a certain type of condition, is not supposed to be serving anymore. And we've all seen documents that refer to, for instance, if a trustee develops incapacity, if a trustee develops a disability, and things like that. Those definitions can be very important and should not be placed in documents without good thought. I did a survey of law around the country looking at the Uniform Act, things like that, and I found that there are a number of definitions that we see built into documents that trigger the succession from one trustee to another. And these can be full of ambiguities, subject to challenge. My favorite one, an example I'll give to the audience today, is that we often see a person is incapacitated, incompetent, or what have you for purposes of triggering a succession, a successor trustee provision in the trust. And it says, if the person's treating physician says that they are. So what's a treating physician? I looked around a lot of state statutes, and one of my favorites is this example from Montana. In the Montana medical marijuana law, it identifies where a treating physician may write a prescription for a person to receive marijuana at an approved dispensary. And basically, all it requires to be considered treating physician is that the person have a bona fide physician-patient relationship with the person for whom they're prescribing. That sounds like something that is not a terribly high bar. And if you had a document that says incapacity or lack of competency as determined by a treating physician, and you didn't have a definition in the document, perhaps you would say, well, in the absence of some type of definition, here's one from a statute that we might try. And that physician might not have much history with the person at all, yet a treating physician is whom we're going to look to in a document to determine whether someone's got the capacity to keep serving as trustee or not.
Well, that is surely, a situation that none of us want to be in.
Well, Brad, as they say, the best laid plans. We've talked about what you can do. We've talked about what your objectives are, what you're trying to avoid. At the end of the day, a lot of this depends on the human beings involved and the courts involved, if it unfortunately winds up in that situation. And next week, you'll be hearing from Kim Kamen and Tara Pleat on tips for dealing with and drafting for clients with diminished capacity as a wrap-up to this series on diminished capacity. Thank you.
Thank you so much, Brad and Julia, for this wonderful discussion regarding practical tips and considerations in dealing with incapacity litigation. I really appreciate your perspective.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review.